What do you mean when you use the term the law market?
Well, basically, the idea is that companies and individuals much more often and much more easily than in the past can move around or contract for the laws they want to govern their relationships. And so countries and states, in an effort to attract those businesses or attract the assets that people have, end up attempting to or competing with one another to supply the most desirable laws. So we end up with individuals and companies, private entities, and citizens as demanders of law, and states and nations as suppliers of law, and that creates its own market for governing laws.
So give me an example of how this works. Could I take one law from one state and another law from another?
You could for different types of contracts. So if you wanted to set up a trust fund and use the beneficial laws of Delaware, you could do that. At the same time, if you wanted to go gamble or engage in prostitution in Nevada, you could do that. If you wanted to enter into a same-sex marriage in Massachusetts, you could attempt to do that. If you wanted to form an employment relationship with favorable laws for your employees in Connecticut, you could do that as well.
Now, don't people normally have to live in the state to follow that law? So how do you make that work if you don't live in all these different places?
Well, if you are entering into a contract, you can attempt to write into the contract the law that would govern your relationship. And you wouldn't necessarily have to live there to have that governing law. As it stands, most courts in most situations will enforce those what are called choice of law clauses. In some cases, they are not enforceable, but ultimately the question gets left to the court.
So what are the benefits of having this type of choice of law?
The benefits for having a choice of law are that individuals can pick the laws that best suit their situation. So it's not always the case that a single type of governing law fits all contracting parties. So some people want to live a particular way or do their business a particular way, and if they can choose a governing law, they can choose the law that best fits their own personal needs. Also, people who transact business in multiple jurisdictions or companies that are spread across the world end up having to form multiple company policies if they have to comply with multiple jurisdictions' laws. But if they could have their business or their affairs run according to a single law by choosing that law, that makes it much more easy for them.
Now, it seems like there are a lot of risks to this, especially maybe for the consumer or being able to skirt environmental laws or things like that. So what are some of the risks associated with this?
Absolutely. So if you have two sophisticated individuals and they're contracting for a single law, and that law or their affairs don't affect other people, our view is one should be able to choose their governing law. But if you're going to have negative effects on third parties, as is the case for environmental harms, or if one of the parties to the contract is unsophisticated and doesn't knowingly choose the governing law, as would be the case for consumers, then there are some perils. And we talk about the trade-offs in our book, and really what we're trying to do is find a procedural mechanism to best resolve the problems. Our view is that it's the legislature of a state or a nation that should make the decision about whether to block the law market to protect consumers, the environment, or something else.
So you're saying a state in general will say, either we support a law market or we don't support a law market.
Right. So we're saying that the legislature should be able to say, law by law or issue by issue, whether a party's choice or attempt to get out from under a regulation is valid, is acceptable. Right now, the question is left to courts who decide after the fact with the uncertainty for parties. We would like to push that decision to the legislatures for interest groups on either side to represent the various concerns that may be at play and to provide certainty for parties up front about whether they can choose their governing law or not.
Now, I just heard something this morning on the news that was talking about same-sex marriage, which you brought up, where people were able to follow the state law, but then when they went to the federal level, the federal government said, we don't we're not honoring this law. So what do you do in that circumstance when you're going on to the different levels of law?
Right, and so we could have a situation about governing law that occurs across the states. We could have a situation about governing law that occurs across nations. One of the benefits of the law market is that to the extent that we're comfortable for people to choose and we allow people to choose, we could allow lawmaking to occur at a somewhat lower level of government. So you could have experimental laboratories across the states rather than the federal government stepping in and resolving the problem. On the other hand, to the extent that states allow for the choice of problematic law, then you end up having federal government step in and trying to fix the problem. And same-sex marriage is an international question now, so it's illegal in most of the United States, but legal and valid in Canada, for example. And so now we've got a question of governing laws across national levels. So it's not really the case that just because Congress makes a determination that the problem disappears, it's just competition at a new level.
So do you think creating a law market would create more lawsuits or help prevent lawsuits?
Well, if the law market exists, whether we like it or not, because people are mobile and assets are mobile and companies are mobile, but our solution to push the resolution of the extent to which parties and companies can choose their own governing law to the legislature would be one that should create more certainty. And also if we ask legislatures to be careful, not just in fashioning the law, in deciding what the law should look like, but in deciding the extent to which that law can be circumvented, that we would have much more careful decision making than we do when we ask courts to make that determination.
Now, I know you've talked about this a little bit, but talk to me more about how this could work for either an average person or a small business.
Well, average people and small businesses may think about choosing their governing law less often. So I would say the average person may think about where to retire, and that may turn on governing laws. The average person may think about where they want to marry or whether they want to enter into a living will. And they may think about governing laws in those circumstances, but they wouldn't necessarily think about it more broadly. Small businesses get forced into thinking about governing law just as frequently as large businesses do. If it turns out there's a set of laws that businesses in general find to be superior, we should begin to see standard forms, standard choices of law that would kind of economize on the need for the small business to have to know too much about governing laws. But nowadays, especially if you're doing business on the internet, you ultimately need to know a fair amount about what the governing law is in various places.
Now, that's an interesting idea to bring up, is the internet. There are some businesses where they're all online or things like that. Right now, how does that work with what laws they should follow, and what do you suggest they should be able to do?
So much more frequently today than was the case even a couple of years ago, you will see businesses online trying to provide for their own governing law. And often that's a positive move in the sense that it's an online business trying to conduct their affairs across the world, and to provide some certainty about what the governing law is helpful to business customers, helpful to savvy consumers. The downside, as always, there's always this attention, is when businesses set themselves up online, provide for a governing law that interferes with legitimate regulatory efforts of other states. So, for example, across the United States, states are attempting to regulate payday loans, the amount of interest that can be charged, late fees, the amount that can be taken out in terms of for payday lending. But online businesses are setting up sites saying, for our purposes, the law of Costa Rica applies to this payday loan. And their payday lending practices aren't regulated at all. Should we allow payday lenders to get online, lend money to Tennessee residents, circumvent Tennessee regulations by placing this choice of law clause on their website? Same thing with online gambling sites, right? Set up in Antigua, where gambling is perfectly legal and unregulated, and then derive most of your profits from gambling with U.S. citizens, where gambling's heavily regulated. So,
but technically, the people are usually signing off and are supposed to be reading the fine print, I suppose, on those websites saying they agree to follow these laws.
That's right. And in both of those situations, you may well have individuals, even if they know the consequences of the laws, still wanting to transact, right? If you still want a quick loan until payday, you might be willing to circumvent the Tennessee regulations that are there to protect you in order to get that money.
Right.
Same thing with online gambling. Well, sure, Tennessee might have regulations, but the whole point of getting online is to circumvent those regulations. So now we have a situation where we might well have sophisticated individuals, or at least indifferent individuals, but yet we've got the state deciding that they want to play a paternalistic role. So our view is if the state wants to play a paternalistic role, that's fine. It's just that the legislature needs to be clear about what the governing law ultimately is.
Now, as always, part of laws are lawmakers and dealing with politics. What is the feeling from politicians about this whole idea of regulating a law market or allowing this?
Yeah, so often lawmakers don't think about the extraterritorial effects of the laws they pass. They pass laws, if you look at most statutes on the book, this conduct is illegal, period. This behavior is not permitted, period. It's often the case that lawmakers are not paying attention to the fact that people can move outside of their jurisdictions. It's only after the fact the law gets passed, assets disappear from the state, then the state begins to water down its restriction or regulation. What we're asking lawmakers to do is to think up front, think ahead of time about the extent to which they want their laws to be enforced, even if some piece of that transaction is occurring someplace else, or even if the parties choose some other governing law. And if the fight can be had in the legislature, yes, politics are involved, but what we're hoping is that the interest groups on both sides will come, and in a sort of adversary context, as opposed to a one-side interest group context, that the decision making that ultimately comes out of the legislature is a stronger, wiser decision making that might otherwise be the case.
Yes, because it seems like there are a lot of laws that once they go into effect, they never change. But this whole idea of a law market seems like there's a lot of evolution to it. It's something that grows and changes. What's your take on that?
Yes, that's absolutely right. So one example is there's something called the rule of perpetuities. It's a property law rule that plagues first-year law students that makes it hard to commit your property too far into the future. And it's a rule that has existed for centuries, and it has disappeared rapidly in the past 10 years in a close majority of states in the United States.
Why is that?
Delaware decided if it got rid of the rule against perpetuities, then new types of trust funds could be set up that weren't available before. That was appealing to individuals with assets who wanted to set up trust funds, and other states began to follow suit. So it's this increasing mobility coupled with new needs for new times that ends up having tremendous force on states to reconsider the rules, the laws that they've had governing in the past.
It seems to me that in this economy, not only states but different countries are really battling to get business, to get more people to bring more money into the states or countries. So how do we prevent these laws from being so weakened that they're not really helping anyone or protecting anyone?
That's an interesting question, because one might argue the opposite, that a lot of the economic woes we're suffering now may well have been the consequence of the fact that it was too easy to circumvent financial regulations in individual nations. And we're beginning to see now the effects of enabling that circumvention in order to attract money and assets into the state. And I think it's forced states as well as nations around the world to rethink the extent to which those laws should be circumvented. So I think the focus on circumvention is stronger than ever, but it will be a good question to see going forward how those economic pressures affect the ultimate governing laws.
So if you wanted, had kind of an ultimate thesis to this book of what you want people to get from this book, what would that be?
Well, first, that there is a law market out there, whether we like it or not. Mobile assets enable companies and wealthy individuals to choose their governing laws. Second, that legislatures should pay attention to the issue, to the problem when passing their laws, and that they should think hard about which of their laws are essential enough that they're willing to accept the fact that some assets might leave the state if those laws can't be circumvented within the jurisdiction. But that third, legislatures rather than courts are the right place to house these questions, because the parties and entities deserve some certainty, one, and two, it's much easier to shut down the negative effects of the law market with clear legislative policy than it is with vague court standards.